Ladies and gentlemen, we are now ready to start the afternoon session. The second plenary will be on recent competition policy initiatives, legislative developments, and challenges ahead in the unilateral conduct area. Now, I would like to pass the floor to the moderator of this session, Mr. Daniel Guarnera, Acting Chief Civil Conduct Task Force, Antitrust Division, U.S. Department of Justice. Mr. Guarnera, you have the floor.
Thank you so much. Welcome to the second plenary panel of the workshop. Again, my name is Dan Guarnera. I'm the Acting Chief of the Civil Conduct Task Force at the U.S. Department of Justice Antitrust Division. The Civil Conduct Task Force is a relatively new addition to DOJ. We were created just in 2020, and we're dedicated exclusively to investigating and litigating civil non-merger matters across all industries. It's an honor for me to moderate the panel this afternoon, and I know that I speak for all of the panelists when I thank the JFTC for hosting and organizing this event. Before I turn the microphone over to our wonderful panelists, I'd like to make three brief observations about unilateral conduct policy today. None of these observations breaks new ground, but it's my hope that they provide a big picture framing for our discussion this afternoon and identify some of the common themes that I expect will recur in several of the presentations on this panel. The first observation is that the large number of jurisdictions worldwide that are actively considering or implementing new policies reflects an emerging consensus both that unilateral conduct by firms with market power can have significant harmful effects on competition, and that policy levers like law and regulation are an appropriate response. As evidence of this renewed legislative interest to concerns over single firm conduct, my own country, the United States, offers an example. Our anti-monopolization statute has not changed significantly since 1890, yet in these last 2 years, the House and Senate Judiciary Committees in Congress have voted favorably and with bipartisan support on multiple bills designed to restrict certain forms of unilateral conduct. Now, none of these proposed legislative reforms have been enacted yet in the United States, but the attention that unilateral conduct issues have received in Congress reflects, I think, reflects more broadly the importance that these questions occupy in current policy debates in the United States. And of course, our panelists today will talk about unilateral conduct initiatives in 5 other jurisdictions this afternoon. The second observation is that concerns about conduct by large digital platforms are driving the policy discussions in many jurisdictions. Perhaps this is not surprising, given that some of the distinctive features of digital markets and digital platforms tend toward market power, such as network effects and returns to scale from large data sets. Moreover, as more and more of the global economy and our everyday activities occur online, it makes sense that scrutiny of digital platforms would follow. Much of the policy work on digital platforms is still new, and the effectiveness of various policy interventions is still to be determined. Even so, the current attention on digital platforms prompts a question: what comes next? Will the experience legislating in the digital platform space prompt other market-specific competition reforms? And if so, in which markets? Or might the experience with new digital platform policies result in reforms to general industry-agnostic competition laws like the Sherman Act in the United States? In other words, the effectiveness of some of the digital platform policies we discussed today may determine the agenda for the ICN Unilateral Conduct Workshop in 2033. My third and final observation is that because of the broad global interest in unilateral conduct, especially by digital platforms, the benefits from international dialogue are especially great. As the Unilateral Conduct Working Group's report shows, many countries have identified similar competition problems presented by digital platforms, most of which have a global reach. The policies under consideration have some similarities, but also some important differences. We all stand to benefit when we learn from each other's policy experiments and identify which policies prove the most effective. Recognizing the importance of international dialogue and discussion on these important topics, it's my pleasure now to introduce our panelists. Each panelist will deliver prepared remarks on legislative and policy initiatives in their jurisdictions. And once they've done so, we welcome an interactive discussion with those in the audience today and those participating online. And so as they present, please jot down the hardest questions you can think of for our panelists. Our first panelist this afternoon is Anna Barker. Anna is the Executive Director of the Digital Platforms Branch at the Australian Competition and Consumer Commission. She works in the ACC's Digital Platforms Branch, is leading work on the development of a new regulatory regime to address competition and consumer issues in digital platform markets. And she previously worked as principal economist at the ACCC. Anna, I turn the microphone over to you. Anna, hold on 1 second as we work on the volume here in Tokyo. Or maybe you're on mute.
Is that any better?
Yes, thank you.
Great, no problem. Sorry for that. I was just thanking you for the invitation to speak today and for the organisers of this great event. Sorry to not join you in beautiful Tokyo, but great to be able to join you virtually. I've got some slides, so I'll try sharing those. Hopefully we don't have any more hiccups. Okay, can you see that okay? Can everyone see that in Tokyo?
Yes.
Fantastic, thank you. All right, so the ACCC has been looking at digital platform issues since 2017, when we first looked at the impact of digital platforms on the supply of news and journalistic content in the digital platforms inquiry that was finalised in 2019. Since then, we've looked into the ad tech stack as part of the 18-month digital advertising services inquiry in 2021, and we've worked with Treasury to develop the News Media Bargaining Code, which was between 2020 and 2021. And we've also examined competition and consumer issues related to digital platform services as part of our 6 monthly reports under the Digital Platform Services Inquiry. So what have we done to date under that? We've looked at online private messaging in 2020. We looked at app marketplaces in March 2021. Search defaults and choice screens in September 2021. General online retail marketplaces in March 2022. And then in September, the latest one we've released is on regulatory reform for digital platforms. And then we've got our next report due, because the 6-monthly reports don't stop, in March of this year, and that'll be on social media services. So today I'm going to concentrate on our regulatory reform report. So why did we look at regulatory reform now? So we've been looking at digital platform services for a while, and we've identified significant competition and consumer harms. And that's in the form of financial losses to scams and unresolved disputes, reduced choice and inability to make informed choices, and reduced innovation and quality, and in some cases prices as well. We've also observed limitations of the enforcement of existing laws. These cases take an awfully long time to take to court. And we've also seen that enforcement actions take a long time, and even successful litigation may not adequately address those systemic and widespread conduct that we've observed, given the fast and moving nature of digital platform services and the characteristics of digital platform markets. We've also found that remedies have limited ability to address the effects of the conduct after it's occurred. So the conduct we've seen is widespread, entrenched and systemic. And the positions of substantial market power held by the large digital platforms give them the ability and incentive to engage in strategic conduct to entrench and extend that market power. So we've seen as well that there's significant international momentum regarding the need to do more on digital platforms and the need for new regulatory regimes. We've seen that with Europe's Digital Markets Act, Germany's 10th Amendment, the UK's proposed pro-competition regulation, and Japan's Act on improving transparency and fairness in digital platform markets. As a smaller jurisdiction, we see benefits from international alignment on approaches to digital platforms, given the global reach and resources of these firms. So given all of this, our fifth report looked at whether new regulatory tools are needed to address these issues, and if so, what forms they should take, who they should apply to, and what the content of the rule should be. We made 4 recommendations to government, 2 on the consumer side, 2 on the competition, because the ACCC covers both competition and consumer issues. On the consumer side, we had an economy-wide recommendation for a new prohibition on unfair trading practices and improvements to our existing unfair contract term laws, which has already gone through in the latter case. We also thought there needed to be new digital platform requirements in respect of processes for dealing with scams, harmful apps and fake reviews. And we thought as well there was a need for mandatory dispute resolution processes and an external ombud scheme. But now I'll go more to the competition measures. So the competition measures, so I'll go back a second, I won't bother. So we had 2, the main thing we've recommended in respect of competition is a new regulatory framework to address the competitions we've observed. And that would be a new competition framework that would apply to designated digital platforms. And then there would be codes of conduct that would apply in respect of particular services. So there's 2 key elements to that. There's the designation on one side and the code of conduct on the other. So what we want to capture with the designation is platforms that can meet criteria that reflects the fact that these platforms have a critical position in the Australian economy and both the ability and incentive to harm competition. So we think the criteria could be based on quantitative or qualitative criteria or a combination of both. And we think that the designation could be in respect of both the digital platform digital platform itself and the services that it provides. There would then be service-specific codes of conduct that would include targeted and upfront competition obligations. And we think overarching, you'd have high-level principles that would guide those that would be in the primary legislation.
And I'm sorry to interrupt you. Could you make your PowerPoint full screen if you have the chance?
It is full screen for me.
Oh, okay.
So I'm not, now I've gone too far. So I'll see if I can try again. Is that better for you?
We're not seeing the slide presentation, but if maybe you just manually select the slide that you're on,
okay,
that might be best.
Sorry, always the technical problems of being, okay. Is that any better? Otherwise, I'll just talk through it anyway.
We can see the slide. We can see the slide that you're on now.
You can see that now? Great. So we thought the development of a code of conduct should be informed by high-level principles that would be set out in legislation. And we proposed 3 high-level principles, those being fair trading and transparency for digital platform users, competition on the merits, and informed and effective consumer choice. The codes of conduct would then set out targeted obligations to address anti-competitive conduct and also to reduce barriers to entry. And the types of conduct we observed and the issues we observed covered things from anti-competitive self-preferencing, anti-competitive tying, exclusive pre-installation defaults, frustrating consumer switching, denying interoperability, data advantages, a lack of transparency, unfair dealings with business users, and exclusive agreements and price parity clauses. So in terms of the next steps and future reports, the Australian government has been consulting on the report's recommendations, and that consultation closed on the 15th of February. And we're expecting a response from the government in the coming months. As I said, the next DPSI report is due end of March, and that's on social media services, and that will be released hopefully in the month or so after that. And the topic of the 7th report will be made public soon. Okay. So hopefully you can see me again now. Yeah, yes. Great. Okay, well, thank you. Happy to take more questions later. Sorry for the technical issues.
Thank you, Anna. Our next speaker is Ryota Inaba. He's Director of the Office of Policy Planning and Research for Digital Markets at the JFTC, which leads the JFTC's competition advocacy in digital markets, including through the dissemination of a series of market studies on online platforms and policy proposals for a new regulatory framework to address competition issues in digital markets. He previously served as Chief of Staff to the Chairman of the JFTC and as a liaison officer in the Embassy of Japan in Washington, D.C. Ryota.
Oh, thank you, Dan. I'm really honored to be here to join this panel as a representative of their host country, Japan, together with colleagues from all over the world. And as Anna said, digital markets have created new challenges for competition law enforcement and policy. We, the competition authorities, are working on how best to address those challenges by opening investigations, and conducting market studies, and even reforming and developing regulations. And just after I heard Anna's presentation, I realized again that we are in a very similar situation where we're facing a lot of challenges to address concerns about the exercise of market power by online platforms. And in such digital era, I see it invaluable to have this kind of panel to exchange views and lessons from a variety of authorities. And today, I'll speak about the recent JFTC's competition policy initiatives and legislative developments in digital markets in Japan, especially focusing on the Act on improving transparency and fairness of digital platforms and a possible introduction of ex-ante regulation in the near future. JFTC has been in both active law enforcement and competition advocacy to address competition issues in digital markets. I think in addition to rigorous law enforcement, competition advocacy is a material tool to address competition issues in digital markets. And JFTC makes policy proposals to contribute to the discussions in the whole of the government about the development of new rules for digital markets to complement the Anti-Monopoly Act or Japanese competition law based on the results of market studies. And in 2019, JFTC conducted market studies into online marketplaces and app stores and made proposals to introduce a new rule to promote voluntary efforts by online platforms to improve fairness and transparency in their business operations. And their headquarters for digital market competition has determined to introduce a new rule based on the JFTC's market studies, namely the Act on improving transparency and fairness of digital platforms, or TFTPA, which came into full operation in 2021 to complement the Anti-Monopoly Act. And I'll briefly speak about regulatory framework of the TFTPA. The TFTPA only targets large-scale online platforms designated based on their quantitative threshold, such as annual domestic turnover of 300 billion yen, or about $2.2 billion or more, for online marketplaces. The TFTPA also stipulates that the involvement of the government is to be kept minimal on the basis that digital platforms must take voluntary and proactive efforts toward improving the transparency and fairness in their operations in order to take appropriate balance between regulation and innovation. So that is to say, this adopts a co-regulation approach which stipulates the general framework under laws and leaves details to digital platforms' voluntary efforts. And I think that the Act has a similar regulatory framework to the P2B regulation in the EU. And the Act requires designated platform operators to disclose terms and conditions and send a prior notification of changes in terms and conditions to business users. And in order to ensure that online platforms' efforts will lead to better transparency and fairness in their transactions, the Ministry of Economy monitors and reviews their designated platforms' operation. The Ministry of Economy can also request the JFTC should take appropriate measures under the Anti-Monopoly Act when a conduct of a digital platform is suspected to violate the Anti-Monopoly Act. The expected laws of the TFDPA is to prevent abuse of a superior bargaining position, which is restricted under the Anti-Monopoly Act, through those kind of regulatory framework under which the JFTC and the Ministry of Economy cooperate and collaborate to ensure that the transactions between large online platforms and business users are fair. And we see that designated online platforms' business operations have improved to some extent so far after the implementation of the Act. But I think it's too early to evaluate whether the Act is functioning fully effectively. And let me move on to the next topic about a possible introduction of ex-ante regulation. The JFTC just released a market study report on mobile OS and mobile app distribution the last month and proposed developing a new regulatory framework beyond the existing competition laws, including the introduction of ex-ante regulation like the DMA in the EU. The report found many competition issues, including self-preferencing and charging a high commission in a mobile ecosystem where Google and Apple control with strongholds on network effects and user lock-in. However, enforcement of the AMA can take considerable time because of complex market definition and burdensome proof of harms. It's also difficult, I think, to take effective remedies to restore competition enough in the market against digital platforms' anti-competitive conduct and even against their condition of highly concentrated markets where tipping has already occurred. And to overcome those challenges for the existing competition law enforcement in complex and fast-moving digital markets, we may need some new tools to be able to effectively prevent and fix anti-competitive conduct by creating a level playing field for third-party apps and mobile app stores, and also to intervene proactively to promote competition. And I hope discussions towards registration will be advanced in the whole of the government, and the JFTC will continue contributing to the discussions. And finally, we can see the same discussions on regulatory reforms for digital markets over the world. As I said earlier, we have common global challenges to address competition issues in digital markets. And I think the biggest challenges not only come from the characteristics of complex digital markets and even from the existing regulatory framework, but also come from the big tech's high capabilities. I mean, they gather talented human resources, the best and brightest, and they are very tough. So let's keep working closely with each other in gathering wisdom from over the world to overcome the challenges in digital market. Thank you.
Thank you, Ryota. Our next speaker is Chris Jenkins. He's the director of the Digital Markets Unit at the UK Competition and Markets Authority. Chris previously served as an economics director, leading the analysis on a range of mergers and market investigations, including the CMA's market study into online platforms and digital advertising. Chris.
Thanks very much, and thank you very much for inviting me to speak on this panel. I'm very much enjoying my first trip to Tokyo. I want to just say a few words about the challenges as we see them in the UK from digital markets. Can you hear me okay? Does that work? No. Is that okay? Yeah. Is that better? Will I try this? Is that working now? Yeah. No. I'll try this. Okay, I'll try this one. Does that work? I will set out how the UK sees digital markets issues and some of the legislative proposals for how we might tackle them. You will see some similarities between my presentation and other panelists, I think. Okay, so I work currently in the Digital Markets Unit, which is part of the CMA, the UK Competition Authority. The DMU has been established to oversee a new ex-ante regulatory framework, which is overseeing the most powerful digital firms, with the aim of promoting competition and innovation and protecting consumers and businesses from unfair practices. We don't currently have legislation. Our government is committed to introducing legislation in this session of Parliament, so we're expecting legislation shortly. So what is why do we think we need new legislation here, and how do we see the competition problems in digital markets? I think very similarly to others' contributions on the panel, we see, first of all, that there are specific features of large platforms in digital markets, which, including network effects, the use of data, and economies of scale and scope, which tend towards market power, and that these features can be exacerbated in some cases by behaviors by the firms to entrench their market position. The firms can also potentially use mergers and acquisitions to build a strong position and reinforce. And I think the important point here is that the accumulation and strengthening of market power can have, in some cases, harmful effects on consumers. As previous panelists this morning have noted, I think it's really important to say the big platforms in digital markets in general have created really big benefits for users. The innovation that they provide is great for consumers, but that doesn't mean that we shouldn't be worried about cases in which market power is creating anti-competitive effects. And those harms can be, in some cases, monetary harms in a kind of normal sense. So, for example, in digital advertising, we found that Google, for example, and Meta were able to earn excessive profits, partly through prices in the advertising markets, but also there could be wider harms through extraction of data and actually through dynamic harm to innovation in future, and maybe that's the most important thing to focus on. Excellent. So what do we see? Why can we not just use existing tools? I think it's important to say that existing tools, so antitrust enforcement, markets, cases, can make a difference in these markets, and it's important to use the tools we have, but we think there are limitations. So as you see on the slide, a number of reasons. One is that antitrust tools tend to be backwards looking. They're generally about penalising existing conduct rather than shaping future behaviour, which we think is really important in digital markets in particular. Second, they're slow to remedy problems. Maybe that is a failing of competition authorities, but antitrust cases, I think, globally typically take a long time. And antitrust cases tend to have to be narrow in scope. This is an important way of being able to mount a successful case. But in digital markets where often the behaviours are linked and there are patterns of behaviour across a firm's ecosystem, it's very hard to tackle those types of behaviours through traditional tools. Sort of related to that, I think there's a challenge of how we create effective remedies in these markets. Most antitrust tools don't give us very effective powers to design remedies, and certainly not to test what remedies work and update them, learning the lessons. There is some risk of incoherence if we're taking lots of different cases on different types of conduct, and also capacity challenges. So we find that running antitrust cases is very resource intensive for the agency. So that's really the reason why we think we need change. And then, so this slide sets out the government's proposals currently for the new pro-competition regime in the UK. The first thing to say is that digital markets are not just about the biggest firms. There is conduct which other digital firms can engage in which might harm consumers. So we think that the overall framework needs to be modernized in certain ways. But a lot of the focus of the regime is on the largest firms. And we've developed a concept of strategic market status. So under the regime, we would have the power to designate firms for particular activities as having strategic market status. And that means that they would have substantial entrenched market power, which gives the firm a strategic position in a particular activity. And I think it's probably quite important to say that it would be targeted on activities. It's not the whole firm that would be designated necessarily. And then when SMS has been designated to a firm, that would allow us to impose 3 types of requirements or remedies ultimately. The first are conduct requirements, which you can think of as ex-ante principled rules governing the firm's conduct, which is about trying to protect against the exploitation of market power and ensure that competition around the ecosystem of the large firms can operate effectively and doesn't stifle innovation. The second is that we would have the ability to impose pro-competition interventions, which would be interventions trying to tackle the root causes of market power in these markets. So this would follow a longer process of consultation and investigation to design those remedies before we could implement them. And finally, there are proposed to be some changes to the merger rules, which essentially are around SMS firms having to notify us of all of their transactions. The UK has a slightly unusual mergers regime, which is a voluntary notification regime for most firms. So this would be moving to a compulsory notification regime, essentially, for the largest firms with SMS. So that's the shape of the regime. I just very briefly, I realize I'm probably out of time, but I just wanted to mention that we, alongside kind of thinking about this new regime and new tools, we're using our existing tools. And I think, I mean, I can talk more about these individual cases, I won't go through them now, but I think it's important to use a range of different tools. For example, in the UK, we've carried out some detailed market studies, particularly in online platforms and digital advertising and in mobile ecosystems. And I think those have been very helpful for us in really understanding the business models of the firms. And they have led to some enforcement cases. So many of the cases you see on the left-hand side are cases that came out of conduct which we explored in the market studies. And I think the market studies, or a similar process, we would see as being important for the DMU regime, where we think it's very important to understand the detail of how these firms work in order to design conduct requirements or remedies which are effective. So we think you should, as far as possible, kind of tailor remedies at the specific activities in question. So I will leave it there, and thank you very much for listening.
Thank you, Chris. Our next speaker this afternoon is Joseph Mutale. He is a senior investigator in the Department of Mergers and Monopolies at the Competition and Consumer Protection Commission of Zambia. In this role, he supervises investigations and assessments on mergers and abuse of dominant cases, and he previously was an investigator in the Department of Consumer Protection. Joseph.
All right, thank you very much, Daniel. Are you able to hear me?
Yes.
Oh, brilliant, thank you. I would like to take this opportunity to appreciate you for the privilege you've accorded my jurisdiction to share their experiences with regards to unilateral conduct. Okay. Can you tell me, are the slides moving there?
No, you're still on the first slide.
Okay. Just a moment.
Yes, there we go.
Okay. Oh, thank you. Thank you. Okay, so I'm just going to share an experience of a particular case which the Commission looked at. This should be some 8 years or so ago. And this was where we drew some of the lessons which I'm going to share in the presentation. So we looked at a particular case. This had to do in the manufacturing sector, in the agriculture sector, for a particular manufacturing company. So basically, the allegations were to do with anti-competitive conduct. And this manufacturing company was more like indicating to its clients a list or details of their crop protection agents to be used for a particular farming season. I should be able to mention that this company is engaged in contracted farming. So it contracts certain companies to do with the growing of a particular crop. So what was the allegation again was that it was dictating to the suppliers of dictating to the farmers the supply of the crop protection agents which they were supposed to use. So our findings in this investigation, basically we were supposed to establish that the particular company is dominant for us to proceed, which was established. And the other thing which we found was that there was a unilateral decision by the said company to direct its contracted farmers to buy the crop protection agents specifically from the 2 suppliers which it had prescribed to them. The other thing is that upon a conclusion of investigation, the case was presented to the board, and the board gave a directive where this particular company was fined. But there was an appeal, as they were aggrieved with a decision by the commission, so they had to appeal through the relevant procedures and the channels, which is the Competition and Consumer Protection Tribunal, which heard the case, but the tribunal still held the position of the Commission. So I should be able to mention that this particular case is still under appeal before the High Court of Zambia. That's why I couldn't go into details to mention the name of this company. But what are some of the developments which came out from this particular case? So we were doing our investigations. We were using Section 16 of the Competition and Consumer Protection Act. And this particular section has got, as I've put it in inverted commas, shall, which means it's supposed to be a per se violation, where no justifications are to be given when you are found to have breached this particular section. But I should be able to mention that the Commission, the way it has been using this particular section of the Act is that we've been applying the principle of rule of reason, such that we allow enterprises to give the reasons why they're engaging in such conducts. But what we learned from the tribunal ruling was that the tribunal gave a ruling that this conduct by the enterprise, it was a per se offense, and no justifications were required. So from this ruling from the tribunal, the developments with the Commission is that we are currently doing the amendment of the Act, and part of the process is that we want to revise the reading of this particular section, section 16, which reads with shall to make it a per se, but we want it to be as we implement it as a rule of reason. And what we learned from the challenges, what we learned from the ruling of the tribunal was that, making it a per se offense is that most of the enterprises we've interacted with, they view the Commission as an impediment to business innovations. So even us as the Commission, we saw this particular ruling by the tribunal as to be something that is discouraging innovation, like for dominant firms. And we understand that from the competition aspect, with innovations, we're going to have economic efficiencies, and ultimately, it's going to have a trickle-down effects to the consumer welfare. They are going to benefit. So from that ruling, that was a discomfort which the Commission got from that ruling from the tribunal. So our way forward now is at the moment that we are still doing the amendment to the Act. We are simply just encouraging the commercial enterprises to make sure that they notify their agreements with the Commission, and this should be is covered under Section 14 of the Act, so that in case just these agreements could be contravening, they may tend to contravene the law. So we encourage them to notify the agreements with the Commission so that we just look at them, because we don't want to be seen as an impediment to business, nor to stop innovations from the enterprises. Thank you very much. That was the presentation. I'll be able to take the questions, I think, after the next presenter. Thank you, Daniel.
Thank you, Joseph. Our final panelist this morning is Vera Pozzato. She left private practice in Italy to join the Directorate General for Competition at the European Commission in 2006. Vera is currently a policy officer in Unit A1 of DG Comp, in charge of antitrust case support and policy. And she previously served as a legal advisor at the European Data Protection Supervisor with a focus on the digital economy, IT systems, and databases. Vera.
Thank you, Daniel. Thank you, everyone. Thank you to the JFTC for having invited me here to explain to you. Is it okay, the sound? some developments and some thinking that is going on at the European Commission in relation to challenges and other initiatives. I will start with one looking at how we are analyzing the case law of the European Court. So we are zooming out a little bit of the digital world to look more at the general standards and our criteria and what we have been looking at and reflecting upon lately, given the developments that have been happening on that front. Then I will briefly mention to you what we are doing in terms of evaluation of our basic regulation, which establishes the framework of analysis. And then I will also talk a bit about the Digital Markets Act. So first, we've had quite a number of judgments in the area of Article 102, which is our basic principle on unilateral conduct. We have had actually more than 32 judgments in these past years, and the fact that we have the past 15 years is indeed the time that has elapsed since the adoption of the guidance paper on enforcement priorities that have been mentioned already this morning. Up until then, there was not a lot of case law in relation to these cases, so we thought it was necessary at this point in time, given the wealth of judgment that have been developed by the European courts, to look at what has happened in the meantime. The judgments concern several types of abuses. Therefore, you can see there in the list from exclusive purchasing, self-preferencing, refusal to supply, conditional rebates, the very famous Intel saga for the EU, tying cases again, and margin squeeze. So you can see that there are a more classical type of abuses and the more innovative, if you want, type of abuse, which is the Google shopping case. The key issues that we have identified and we are still reflecting upon are, in general, as a first point, the standard for intervention for the Commission to bring cases. It is recognized by the court that the aim of our intervention should be to protect competition and the competitive structure and not competitors. And if there is the exit from the market of a less efficient competitors, if it results from competition on the merits, this is fine. And at the same time, we have really seen that the case law has embraced a more effects-based approach. So looking at the dynamics, looking at what the market looks like, looking at the economic reality of the market and the effects that the conducts have. And the standard for intervention is indeed, as was mentioned this morning, is a little bit of a European situation, the exact meaning of capability, likelihood of effects. But it is a fact that the court has told us we are not supposed to prove actual effects. We are supposed to prove potential effects. So this is a very important step for us because we have been facing challenges on this front as well. The third point is a very, very important one, is the role of the as efficient competitor test. And now, of course, we know that this has two dimensions. On the one hand, we call it you can call it the as efficient competitor principle. So when can the Commission intervene to enforce against abusive conduct? And the criterion has been established in the court. The court has mentioned many times that the intervention is guaranteed. It has to happen when the conduct lead to the competitive harm in relation to a competitor as efficient as a dominant company. But at the same time, we do not have to interpret this principle in an absolute way, in the sense that we have to be proving every single time that we want to take an enforcement action that there is effectively a competitor which has exactly the same cost structure, if you want, as a dominant company, because the courts have also told us that the companies, dominant companies, have an importance to the role not to hamper undistorted competition in the market. And there can be markets where the emergence of an as efficient competitor simply cannot happen. This has been clarified in the case law, and we have also seen it in our enforcement practice. You all can imagine in cases like in cases where Google is involved, it is very difficult to imagine with this level of market share, with the level of dominance that this company has, that a competitor can be having the same cost structure and the same efficiency as companies which are characterized by these huge scales. Therefore, what we have taken away from the case law is that indeed we can intervene even when there is a we can say not yet as efficient competitor who can still though put competitive pressure on the dominant companies, because they can maybe come in with a smaller niche product that can, from there they could scale up and start to put pressure on the dominant company. The counter, if you look at it from another dimension, you can see that in certain scenarios, dominant companies, especially in the digital markets, have been really active in identifying small competitors that could be threatening for them, and either they buy them up or they basically foreclose them. They try to shut them out of the market. This shows that this is a real threat, and this means that our intervention is warranted also in these cases. The more narrow view of the as efficient competitor test is indeed the so-called really econometric price-cost test, a test that we probably are all familiar with. And the debate has been, of course, we've been litigating in court many cases. Companies have told us that we have to apply extensively this test. But the courts have told us very clearly, very recently, in the Unilever judgment, for instance, that this test is optional. It's one of the tools that's available in relation to pricing practices to prove the harm that can be done by the given conduct. But it is by no means a necessary tool that needs to be used. And this is very important for us because we have seen it coming back constantly as an element of criticism and as one of the grounds for even losing cases in court. So this is really a very fundamental problem for us. Very briefly, the case law has also clarified the cases of constructive refusal to supply. These are cases where the dominant company can be unduly delaying or degrading the supply of a product, or can be providing access to an infrastructure under unreasonable conditions. The court has clarified that we are not supposed to prove indispensability of access in these cases because this would really put a very high standard for us. So this is very helpful for our enforcement activities. And also the court have clarified that margin squeeze is not a subtype of refusal to supply, but is actually a self-standing abuse. The conclusion, so this is a very broad overview, and there's many other aspects that we've been looking at, but the idea that what I would like to show to you with this is that we've been looking at the case law, and we've seen that the case law of the courts have been identifying ways for us to adopt a effects-based approach, but in a workable way. Allows us to have a way to run our cases that does not put the bar too high for us. We are aware that we have lost cases in court, and these are cases that we've been in part appealing. But the important thing is that we have identified principles in the case law that allow us to bring forward our cases with a workable standards. So we are reflecting on what this would mean in terms of future action on the side of DigiComp. Moving on now to evaluation of Regulation 1. As you know, this is Regulation 1, we call it Regulation 1, is the basic framework for the application of the antitrust rules by the Commission. It is joined by an implementing regulation, and this regulation has turned 20 last December. So it's a good moment in time to take stock of how it worked. And so we launched a very broad evaluation exercise of how it worked, in particular in view of the fact that we need to verify whether the regulation is still fit for the digital age. In a context in which we all have adopted a different way of working, remote working manners, and not only us, but also the companies we are investigating. So we've been asking ourselves, we've been in the evaluation process, this point has been raised. Does it make sense to do physical inspections in company where most of what we're looking for is actually stored in the cloud? Our requests for information are large. They request a large amount of data. We are served with companies, if they don't litigate it, with large amounts of data, and this is becoming a little bit more complicated to manage. It slows down the process because, of course, we have to grant access to this data. Access to file process is really long and lengthy, and At the same time, we are required to act faster in the digital world. So we have all these elements, one going against the other. We need to be fast, but we need to be thorough because the theories of harm are really complicated, and so we need more time. But we have less resources. So all these elements come into the picture and looking exactly at what we can do to make our tools work better for us. What we have been looking at in the evaluation is indeed our investigative power, so how we ask for information, we take statements and inspections. At the same time, we need to ensure the rights of the parties, and indeed also how this can be ensured. We look at our own decisions, how effective they are, the process leading to the adoptions of the decision, does it really lead to successful and satisfactory outcomes? And of course, we've also been looking at how the ECN, the European Competition Network, works, but this is a very specific European angle. Sorry, okay. We've had a broad consultation process that started last year. We have, as you see here, I won't go into the details, we have also commissioned studies, we will hold workshops, and the idea is that we will come out with a staff working document by mid-2024 to take stock of all this exercise that we are carrying out. Now, in terms of feedback that we have received so far from the respondents to our questionnaires, I will just focus on a couple of aspects. As you see, companies look for guidance from us. We have moved away from a notification process to a self-assessment situation, but companies still want to hear what our approach is, in particular in relation to new markets and to new dynamics and how this works. We have issued a new revised informal guidance notice in October that should allow companies to come forward and ask for our views on issues that are of interest. In terms of the procedures in particular, we have been asked to enhance the transparency of our processes, in particular in the phase leading up to the opening of the proceedings. But at the same time, also we have been criticized for the lack of timeliness of our intervention. So discussion has been going on about introducing deadlines also in our procedures. And this is a very, very sensitive topic. And I know that certain authorities have deadlines. We've been discussing with them. There are pros and cons. So we're still reflecting on this because deadlines are important and an important tool of legal certainty, but also it has to be ensured that our enforcement activity is workable and actually effective. At the same time, of course, we are requested to preserve at full the rights of defense of companies and the confidentiality. There have been issues, of course, about the access to file and how this is being carried out. I think the most interesting point is how to go from investigative tools that are based on the paper-based world to type of investigation that take into account the digitalization of the world. And so we possibly have to take a decision on how to update our toolbox. Maybe we will have to move to fully remote inspections or to issue freezing orders on the data of the company so that we can take the company doesn't have the possibility to modify the data once we ask for it. Now, moving on to the Digital Markets Act has been already mentioned several times today by many of the speakers. As you know, it is a proposal of the Commission that was adopted in December 2020 after a very intensive preparation phase. It was finally adopted by the legislators in Europe in September and has come into force. It is a legislation that will be applicable formally from the 2nd of May 2023. Which means that it will the obligations for companies will start to kick in as of that date. It is a tool that does not replace consumer protection legislation and complements existing competition law. It is a tool that has been introduced to address the most egregious issues of non-functioning of market in digital markets. We have seen it's based on our experience as enforcers and also experience of our colleagues from from our twin DG in relation to the functioning of these markets. And the idea of, I assume you all are pretty much aware of the structure of the DMA, But the concept is that there are gatekeepers. Who are gatekeepers? The gatekeepers are companies which are small companies with very high economic power. They have the possibility to connect many users on possibly two sides. This leads them to leverage the advantages that they have, essentially mostly based on data, from one area to another area. What also can happen is that gatekeepers are very big ecosystems which are difficult to challenge because of the high barriers to entry because of the costs that are involved in setting up this type of businesses, and because, again, of their data advantage. This characteristic leads to the fact that there's an imbalance in the market. The DMA, therefore, establishes the possibility to identify gatekeepers or companies which have this particular role and that have these particular characteristics. The requirements of the gatekeeper designation are that they have, you see on the left side, the requirement, it has to have a significant impact on the internal market, and what is the criterion, the quantitative criterion on the right-hand side that has been adopted, again, also with very, very intense negotiations there. You see the requirements are significant impact on the market, the fact that they have to be important gateways for business users to reach the end users, and they have to enjoy an entrenched and durable position, essentially the length of the length for how long they have held this position. So when the company realizes that it fulfills this criteria, then the obligation to notify the status as gatekeeper to the Commission kicks in. And the Commission will have to designate within 45 working days after the completion of the information received as gatekeepers these companies. There can also be other types of identification of gatekeepers on the basis of qualitative criteria, on the basis of a so-called market investigation. But this is by now essentially all companies that they think they will fulfill the criteria already know they are preparing, and I know that my colleagues that deal with the DMA already are in contact with these companies to discuss how this will be carried out. The other fundamental principle of the DMA is the fact that these companies have to be providing so-called core platform services. These are services that are characterized by a number of elements that can be exploited by the companies. These elements are vertical integration, the absence of multi-homing by users, lock-in effects, extreme scale economies, nearly zero marginal costs to add new users, strong network effects, and data-driven advantages. All these characteristics of these services lead to the fact that the company that carries out these services the way they behave leads to a lack of contestability of these services in the market, and these companies also tendentially use unfair behavior and unfair relationships with their customers. So these are the two basic principles, the gatekeeper designation and identification of core platform services. Not all the activities of a given gatekeeper will be subject to the obligation of the DMA, but only the core platform services that will be identified. Now, in terms of what obligations will be imposed on the companies, the idea is that these are very precise obligations that are necessary and appropriate to ensure the contestability and the fairness of the markets, because these are the two main tenets of the DMA, ensure contestability of markets and fairness of behavior of these companies. The obligations will be applied to core platform services that meet the designation criteria. The obligations are directly applicable with only limited possibilities to obtain exemptions on the basis of general grounds. There are two categories of obligation, those that are directly implementable and those that need further specification, so the Commission might need to issue a specification decision, so-called. And the compliance with these obligations kicks in once the designation takes place, 6 months, and the company has to comply with this obligation. Very briefly, this obligation, there's quite a long list of obligations, and they can be data-related, like data silo or data portability, obligation linked to neutrality, so self-preferencing ban, or the issue of side loading. There can be obligations that are linked to the possibility to enhance multi-homing, so provision of parity clauses or anti-steering clauses. And there are specific obligations in relation to the advertising market to ensure that both advertisers and publishers have the possibility to access the data and the tools they need to ensure that their campaigns and their services are effectively what the company providing the advertising services does. So, to conclude, doesn't want me to conclude? Right. So the idea is that we have now this tool. It's a regulatory tool which addresses the most egregious violations of if you want, market failures that we have identified in the market. This is one part, but of course this leaves still space for competition enforcement in digital markets, because there are a number of services that are not covered, there are numbers of conducts that are not covered, and so this would allow us to concentrate our resources on enforcement of Article 102 in areas which are not covered by the DMA. This shows that ex-ante regulation can complement the competition enforcement and ensure that competition agencies can focus their resources on the most harmful cases. And in the future, as we have been doing, in the Commission in the past years, we will continue to enforce, we will continue to adapt to new markets. It doesn't mean that now we gave up on digital markets. We will always be challenged to come up with different ways and new, novel, and push boundaries in relation to these markets. So this is the end of my presentation.
Okay, so we covered a lot of ground, and hopefully you had a chance to write down some difficult questions for our panel. Are there any questions online or in the room here? Maybe as folks think of them, I can start, and I'll direct this in the first instance to Anna, but others should feel free to jump in as well. For those agencies that have undertaken digital market studies in the last few years, do you have any best practices or advice for other competition agencies that are considering similar studies, either in digital markets or in other markets? Oh, you're on mute again, Anna. Still on mute. No. Not yet. No, although I'm impressed by my own lip reading ability. As Anna gets her volume working, I should note that I think I forgot earlier that my comments today are my own and don't reflect those of the Department of Justice necessarily. I don't know if Chris or Ryota, if you have any, or yeah, if you have any comments along these lines.
I'll make a start. So, I mean, I think some of this will sound like common sense, but my experience of market studies is first do as much preparation before you open the study as you can, and really think about the theories of harm you want to test and the evidence you want to gather. I'm sure that is common sense, really, but I think it's very important to set out at the beginning kind of what the scope of the investigation is, so that you can solicit kind of views in a informed way from third parties. I think, secondly, really thinking about engagement and trying to engage with as wide a group of firms as possible. In particular, potential entrants and smaller firms within these markets, to understand where the barriers to competition might be. And the final thing would be focusing on what outcomes you want to achieve. So I think different agencies will have different powers for market studies, but I think in all cases, you have choices around, do you think that there might be enforcement at the end of these cases? Are you thinking about advocacy, sort of new regulation, for example? And all of that, I think, is, as much as possible, it's kind of thinking ahead to what you want to achieve at the end. With apologies, that's probably all common sense, but that was my experience of working on market studies.
You're still on mute, Anna, I'm sorry. Are there any questions from the audience or online? Another question then for the panel, and I guess I'll direct it to you, Ryota, at first, but others should jump in, is how are your agencies thinking about evaluating the effectiveness of these policy interventions? What metrics or measures or other outcome effects are you taking into account?
Thank you. When it comes to the TFDPA, as I said earlier, the expected laws of the TFDPA is to prevent abuse of a superior bargaining position, and which is restricted under the Anti-Monopoly Act. So from this viewpoint, we can evaluate the effectiveness of the TFDPA based on the number of cases of abuse of a superior bargaining position the JFTC faces. And also the TFDPA regulates transactions between the large online platforms and their business users. So we can also evaluate, I think, the effectiveness of the TFDPA by conducting a survey to hear the voices of counterparties of their designated online platforms. And according to an evaluation conducted by the Ministry of Economy, online market price in their app stores, about 70% of business users answered to a questionnaire that information disclosure and the support from platform operators have improved after the implementation of the TFDPA.
Thank you. Chris or Vera, do you have any additional comments?
I think in relation to the DMA, we will have to wait and see what the effects of all these obligations kicking in will be. In particular, I think what will be easier and more clearly identifiable effect to see is that does it change anything in terms of contestability of the markets? Will we see change there? Because that's the basic concern that have been prompting the intervention. And will we see a structural shake-up of those markets? Will this entrenched position, will they be kind of challenged? This, I think, we will only have to see if it works. I mean, the DMA has as provisions that allow it to adapt over time to changes. We will have to see. We will also be looking at, of course, always at the markets from antitrust enforcement point of view, and we will see what changes from our perspective. Will we see other things emerging? Will we see markets that are less prone to abuses because of the fact that there will be more contestability of these markets? I guess we will only wait and see.
And we'll do one last question from the online portal, which is directed at you, Chris, but I encourage others to answer as well. How do you ensure that the pro-competitive regime will deliver its procedural fairness to the market, and what mechanisms does the Digital Markets Unit implement when investigating conduct that occurs?
Yeah. Well, I should start by saying, I mean, we don't have the legislation yet, so the legislation, when it's brought forward by government, will clarify the procedural protections. I mean, certainly we would expect firms to have a right to appeal decisions made by the DMU, as with other CMA decisions. I think the other important aspect before you get to that point is that we want to take a participative approach to developing conduct requirements and other interventions. So that is working both with the SMS firms, but also, of course, with smaller firms, competitors in the market. I think that's important both to ensure that the remedies are effective, so that the conduct requirements are targeted at the business models of the firms and don't cut across them, but also that it brings a procedural fairness in, that we're taking account of views as we develop the interventions.
Thank you so much to all of our panelists.